I just want to say a couple of things that are sort of technical about the paper. So one is that the paper purports to be doing something I don't think it's actually doing. So from my perspective, public meaning originalism as after the recovery of what Chris calls the sense, right, or the intentional meaning, and this is intentional spelled intensional, intentional meaning, right? Or another way of putting it is that we're trying to recover the communicative content, that is the set of propositions communicated by the text. So you're using data that reports extensions in contexts of applications. So the data you provide is about reference, it's about extensions, it's about applications. So there's a missing step here. You have not gone through the work that would be necessary in order to reconstruct the propositional content, right? You have shown that the words are used in certain extensional contexts. So there's sort of a fundamental problem here with the claim the paper is making versus the evidence that it provides. Second technical point. So you talk about implicature, and there's a spelling mistake here.
We fixed it today.
So you just what you are referring with where you're quoting me on constitutional impliciture. You say implicature, and this is important because implicitures work in a particular way that is different than implicature in the narrow sense. And the way that you are arguing about this kind of contextual enrichment just does not work. So what you do is you have a bunch of examples in which right to bear arms, right to having arms, right to taking up arms, right, are then accompanied by qualifying phrases like in your own defense, for self-defense, for the defense of themselves and the state, for the defense of the state, right? So that is just not evidence, one way or the other, of pragmatic enrichment in the context of the Second Amendment. Pragmatic enrichment works from the context of utterance, right? So in the case of the Second Amendment, you just can't get a pragmatic enrichment out of corpus data. And in particular, you can't get it from this kind of corpus data. To the extent this is relevant, and it is somewhat relevant, to the extent it's somewhat relevant, the fact that these phrases are added to the having arms or having and using arms or taking up arms, that they add these qualifying phrases. These are all instances where there is no impliciture, right? These are all instances in which the expression is complete, it's filled out, it's made explicit. So from the fact that people don't use impliture, that implicatures are not present in usages on other occasions, no conclusions can be drawn about whether there is a pragmatic enrichment in the context of the Second Amendment. So there's a lot I like about this paper, but this particular discussion I just think is flat out wrong, and it needs to be taken out of the paper.
I mean, as I understand this, the BYU site is just linked and allowed to be searched at one time some already existing databases, and some, but far from all. And so, I mean, there's just a couple concerns about this. I mean, I'm certainly all for using every tool possible and reading everything you can find. And if this BYU database helps with that, that's great. I think you do a service, and those of us who do this kind of originalist work should probably do more of what you do of trying to, with noting the limitations of it, try to be a little bit more quantitative and transparent about, what kind of, where we're searching, what kind of results we're finding, positive and negative and all that. And I think, that you're showing us, that you're showing us your work in that way is a good thing. That being said, I just don't have. I don't know, I just worry that that we're sort of getting a false sense of security or of determinacy or of completion from this. I mean, just glancing at the BYU site, this doesn't have the documentary history of the ratification of the Constitution. It doesn't have the Annals of Congress. Doesn't have the State Papers series. Doesn't have parliamentary statutes. From what I can tell, the newspapers that it have are not as broad as are available from somewhere else. That might be wrong about that last one, but this is a relatively limited set, and really not a substitute for just reading everything you can possibly find in as wide a range of places as you can. And then the last thing, as I said, I do think that there's some value in trying to be more transparent and quantitative about what we're finding. But we have to acknowledge, in papers like this that are reporting results, that what the denominator is, what the universe is, and what's included in it and what's not, and just be a little bit more transparent about that. What does it mean if 40% of your hits were X or Y? Well, it's going to depend on what's being searched, right? And especially when this main database here includes things like works of fiction, but doesn't include things like the Annals of Congress. I'm a little less interested in that 40% number, and it makes me a little nervous that we're giving kind of a false sense of precision.
It seems to me the paper is making an assumption at the outset about the type of thing that we're looking for, and that assumption is sort of being shaped by the modern legal debate about what the right is. And so I wonder, for instance, if it's the case that Second Amendment rights look like the type of right that I've written about in the First Amendment context, whether the sort of questions you're asking just don't really make sense from a historical standpoint. So the natural right to freedom of speech is an individual right, unmistakably individual. It can also be exercised collectively in an association or so forth. And it can also be controlled collectively by the people through their representatives. And so all of these things would make it very incomprehensible to go back to founding era evidence about freedom of speech and ask about whether it's individual or collective, because it would turn out that in some sense it's both. It's a right that is held by the individual, but it's also a right that's controllable by the collective. And so if that were the case with the Second Amendment, then that would have some pretty, I think, startling ramifications for the type of inquiry that you're engaged in. And so I just wonder whether that sort of hard work about what founding era rights are or were, whether that sort of just logically comes first before the type of work you're doing becomes relevant.
I'm tempted, and we discussed this earlier, of changing the title to Corpus Linguistics and Heller, because we're not really talking about the Second Amendment, we're actually confirming Scalia and Stevens. And the point Judd made, I think, is well taken. We start off with this presumption as a collective or individual. Maybe that's not even the right frame to use altogether. This comes up in the emoluments, where the emoluments have a narrow meaning or a broad meaning. Well, why are we assuming that it has one or the other? So perhaps our paper can be more limited to just Heller. That might be a little bit more modest. And Larry, I'm sorry we misspelled impliciture. I think spell check may have killed that one on our side. So we will fix that. I think we'll also revisit that section very carefully. James, want to?
So just something that Andrew said, with anything, right, the old adage goes, garbage in, garbage out. Now, I'm not saying we're talking about garbage here, but any database, it's important to know what's there and what's not, so you can know what can be drawn from it. And Judd raised something. It's not quite on point to what he was saying, but that made me think of something that's in the paper. that we're not sure about. And that was the fact that there's a difference between a different sense and different contexts, right? So we talked about you can keep books at home for yourself to read, right? The town can keep books in a library for the town to read. And are we really talking about an individual sense versus a collective sense of keep? Or are we talking about just two different contexts? And that's something that we struggle with and we're not sure. And that's, it's an interesting question. But anyway, we want to hear more, so.
Josh and James, there are a lot of things to like and admire about this paper. I think it is likely that interest in corpus linguistics is going to increase in the next phase of our lives. And so, treatments of it are useful. I think this one is admirable in a number of ways, including its attempts really to engage with the limits of what it can show, right? Which isn't to say that there aren't other limits that other people here have pointed out, but the paper is conscious of that, and I think that's admirable. If I had written the paper, I would have changed the last sentence just a little bit, because you write, whatever its limits, corpus linguistics is a tool. Whatever its limits, corpus linguistics is a tool that can help us understand, at least in part, what the Constitution means. If I had written the paper, I would have said it can help us understand, at least in part, what the Constitution meant. But that's a philosophical difference between us that I don't propose to adjudicate right here. What I will just offer this suggestion for this kind of work. Suppose you could have a database that was large enough to satisfy the sorts of, large enough and on point enough to satisfy the sorts of concerns that Andrew was raising. And suppose that you could ask it the right queries in the conceptual ways that Judd is talking about, and ask it the right questions also like Larry's talking about, and so forth. To the extent that you're interested in the words of enacted pieces of the Constitution, I want to make a suggestion about time slicing. The database has everything in the last 40 years of the 18th century. Sometimes the usage of language changes in response to a legal enactment, right? It changes in response to a legal enactment because once words become law, people start using the words under the influence of that law, tactically or rhetorically, or a certain sense of the words becomes salient and patterns of usage change. Such that if you wanted to use corpus linguistics for the sort of thing that it might be able to deliver, what you would really want to know is, what does the data look like up until the date it passes, right? You might introduce noise after that. Now, it might be the case for a lot of enactments that it doesn't change very much, right? So no harm done. But as a matter of keeping the method clean, I would think that people who do this kind of work would want to avoid the risk of that sort of post-enactment noise.
I also wanted to say that there's a lot to admire in the paper and also other corpus linguistics studies. I've been somewhat fascinated by what's happening, I think, in originalist scholarship right now, where in the last few years, a lot of great placements in the law reviews and attention from the media, and now the courts are starting to recognize this work. But I have some concerns, and I just want to kind of flag a couple. One has to do with a basic question about whether, when we do empirical work of any kind, we're going to incline toward or be focused more on data coverage versus explanatory depth. This is a pretty familiar distinction in other sciences, and it's generally recognized, I think, that it's a mistake to be too concerned with data coverage or data accumulation and to the neglect of explanatory depth. And I sort of feel, as I read papers like this, that distinction is important. An aspect of this is, are we treating every data point equivalently, or are some pieces of data, some findings that you discover here, more important than others? And you don't have a theory of that, it seems to me. What you do is go more towards the counting side of thing, where necessarily every data point is treated equivalently. I just find that hard to take on board as a research method in this area. So I'll give you an example. Early on in the paper, you identify the fact that the Massachusetts Declaration of Rights and the Virginia Ratifying Convention's proposed amendment and proposed amendments out of New York and North Carolina all used, I think you're saying, the equivalent phrase, keep and bear arms. But you blow past that, you actually conclude at the end of that paragraph, there were few usages of this particular formula. You then identify some others from, pamphlets from Rhode Island and a book in colonial Virginia and so forth. You kind of create a bit of a wash situation that sets up your conclusion that you begin the next sentence with, which is, we conclude that keep arms and bear arms were distinct concepts. Well, you can certainly gather data to establish that there are many uses where keep arms and bear arms are distinct and being used distinctively, but it just seems to me overwhelmingly salient that 4 publicly produced and well-known documents that are clear antecedents to the drafting of the Constitution and the Second Amendment used a particular phrase. And the fact that you treat that as somehow equivalent to other countable data points just seems to me very problematic. At a critical point in the paper, after you've decided that keep arms and bear arms are distinct concepts, so you're going to come up with the searches that you're going to perform on COFIA, and you give those to us, your first query considered right within 6 word of arms, and then you tell us the search generated 46 results. We categorized each hit based on the following possible senses: collective, individual, both, ambiguous, and so forth. But you don't tell us the criteria that you used for that categorization. That's the critical step. I think this is sort of reinforcing something that Judd was saying. But then we get on the next page, data graphs and so forth. And it continues in this vein. The question is, what is the basis on which we are justified in identifying certain historical, founding era statements as either evincing a collective right or an individual right? Because that's, of course, the question at issue. But you're begging that question in some respects as you get the empirical project off the ground. You need to tell us and justify your theory of why you're performing that categorization in the first place. And furthermore, it has to be replicable, because one of the professed advantages of corpus linguistics is that it's objective, it's transparent, it's replicable. But we all need to be able to take your work product, hand it over to research assistants, or be willing to do it ourselves, and try to replicate your results. And without telling us the basis on which you're performing that categorization, I just don't think we can do that. This is a little bit of an unfair observation, because you wrote a paper that I presume have hyperlinks in all these footnotes, so that anyone reading it could link on it and get to the document. But I have to say, as far as opaqueness, opacity versus transparency, reading this at critical points in the paper, when I wanted to see the documents, or at least know which documents you were referring to, all I got was, word salad or, symbol salad for linking to websites. And I would encourage you, maybe you would do this in a published paper. In addition to linking to the site, give us full citation information. Another concern I have, I don't want to go on too long, but I have yet to see a corpus linguistics paper that's published in these top law reviews produce, either in the volume or maybe independently on a website, a supplement. It's normal practice in the sciences to publish a 3, 5, 7-page empirical paper and to have an 80 or 120-page supplement that's available on a website that makes crystal clear what the data are that you're drawing your conclusions from, so that people can see those findings. In the emoluments paper, James, that you wrote, there is no supplement. In other papers, it's useful to the rest of us to be able to check your work and also to be able to learn about what it is you're presenting, to actually see, or be told at least, the precise documents that are being used. That's a pretty, long process, but it's not like it's expensive, really, because you have that that you presumably have that spreadsheet somewhere because you coded it or somebody coded it. So present it to the world so we can see it. I am very concerned that what's going to happen now with the courts are going to be citing, like you mentioned, this emoluments amicus brief that went in contest to yours in the Fourth Circuit. I read that paper. I learned almost nothing from it, even though I've been thinking about emoluments for a couple of years now, because none of these explanations of the method, the critical choices that are made along the way, the actual data set and so forth are in the paper. And I just worry where we're heading with the jurisprudence and the use of this, this kind of research is not to a very good place. It's actually not transparent, but quite the contrary. Let me just conclude by saying, despite all these negative things I'm saying, I'm not actually negative about the enterprise. I think it is relevant that COFIA essentially consists of 3 data sets: Founders Online, Evans, and Hein Online. I reached out to Stephen Moritzen to ask him about the question, what are the precise texts in Evans and Hein Online? Because for about a year, COFIA was up and running, but there was no answer to that question. And very helpfully, he pulled together, the people who run the site pulled together the actual list of books. So it's about 3,000 pamphlets or so forth in Evans, and then some of the subcategories in Hein, but at least they're listed, right? So that's a start towards transparency. But it's striking that until the ask was made, even that information wasn't available. And so I just would encourage you to become much more scientific, much more transparent, not disavow scientific methods, but actually put it out there in as complete and transparent a way as you can, including the way the paper is written, including the footnotes and so forth. And that's, I think, when corpus linguistics will get the legitimacy that it is seeking as far as a bona fide method to inform the rest of us. Thanks.
So what are we to make of the frequencies? When we learn that a word is used, that there are 2 sentences and one has a 50% share and one has a 20% share, or one has a 97% share and one has a 3% share. Do we ever get to make the inference that the majority one is the one they used? Is it that the majority one is the one they were more likely to have used, mostly enough contextual evidence to the contrary? Is it sort of hard to tell either way, because the most important evidence is just the context from the document? So I sort of remain a little confused about what it is we're to make of that. Because it seems to me like the main thing corpus linguistics adds to just searching Hein Online ourselves is the sort of attempt to be able to have sort of rigorous and consistent quantification. So it's the same documents at a certain balance of documents, so that you get sort of meaningful, comparable percentages and frequencies when you learn something. And I'd like to know what we're supposed to make of the frequencies.
I think that's a theoretical question. Just like in statistics, it's a theoretical decision to make 0.05 the cutoff for statistical significance, right? And I don't think folks have quite worked that out. We're at the beginning of an enterprise, and I'm not sure what the answer is. I mean, I think we felt pretty comfortable with the bare arms because it was so overwhelming. But beyond that, it's 60%, 70%, 50%. I don't know. That's a theoretical question that we're going to have to decide. At what point do we feel like the evidence is strong enough that we could safely infer that this is how people would have understood this in this context? I don't know the answer to that. On John's points, all good points, part of that is a bit of the haste of writing the paper and getting it ready for the conference. And I completely agree. The plan is to put the spreadsheets online so that anybody can access them, to have full citations, to lay out, here was our definition of collective. We actually pulled out a lot of more explanatory material from the paper because we haven't really dove into the literature. And so we decided that we're just going to keep this paper simple for this conference, and here's the numbers, and we'll kind of, but no, I agree completely with what you're saying there. And I think we'll say no more.
So I think this may largely follow up on Andrew's point, but the way in which traditionally I think a public meeting or public original meeting is, to look at uses in legal contexts. So how is it used in the ratifying debates? How is it used in court cases? How is it used in Congress? What, as I understand your article, what you're doing is shifting to kind of broader popular usage. And it's just, I guess the large question that I'd like to hear your thoughts on is, why is that a better guide, to what the words mean in comparison to, when people were focusing in real contexts on, what a phrase meant. So in some sense, it's, why would you privilege kind of the generic context of, the usage in everyday life over the usage in legal context of people trying to construe a particular constitutional phrase?
This is a good pioneering effort, but I share a lot of the methodology issues that have been raised. So we're running out of time. I don't think there's a reason for me to repeat problems.
I mean, the great thing about your methodology is it's transparency with the caveats that John's already raised. So one thing that occurred to me is, could we entertain the possibility...
You need to point that directly at your mouth.
Okay. Since we're... wanted to entertain the possibility that in addition to the right to keep arms and the right to bear arms, there was a third right recognized for the first time in the Second Amendment. It was the right to keep and bear arms. And that corpus linguistics tells us nothing about that third right, because I think you said there's only 2 occurrences of it. Just as it doesn't kill your paper, it's just, here's another possibility, right? But corpus linguistics doesn't help us with that. The other thing is something I'm channeling Eric Siegel here, and also raising something that Josh and I talked about last night, which is why, if there's evidence out there that there's one possible meaning is that the Second Amendment is about an individual right to bear arms. Another possible meaning is that it's about a collective right to bear arms in the context of a militia. Why would we not defer? Why would we not want a court to defer to local officials who've chosen one meaning or the other when both are possible?
So COFIA, actually, you can just look at legal documents, right? So a third of COFIA is Hein, and it's state statutes and court opinions and congressional documents and various legal things. So you can just limit that. There is certainly, I think, a view of some in the room that whether or not we're looking at legal documents or whether we're looking at more ordinary materials depends on the term. Some things are legal terms of art. Some things are just based on their ordinary meaning. And so you would look at the relevant materials based on what you think that is, or if you're not sure what it is, you'd look at both and compare how they're being used differently and have to make a judgment call there. So I think that's why our paper looks both at the Hein materials and the founders' writings and the ordinary materials. Unfortunately, COFIA is a work of progress. It was probably released as a beta version a little early, which meant that it didn't have some of this stuff, and it still doesn't have some of the capability of being able to, I just want to search Hein, I just want to search founders, I just want to search Evans, I just want to search up until 1791. And you can't do that yet, and it's a work in progress. But anyway, I think, Samuel Bray says the Constitution invented a hendiadys, right? To keep and bear arms is a brand new linguistic invention. Maybe that's right. It's kind of hard to figure out if that's true or not, but it's certainly plausible.
I think it was either the last comment or the one before that raised the possibility of the Second Amendment having created something new, a right to keep and bear arms that hadn't really existed in some sense before. And that was somehow connected with the thought that if you can't tell for sure whether this is an individual right or a collective right, why not defer to local officials? And I think that illustrates one of the pitfalls that this kind of corpus linguistic analysis standing alone can lead to. A lot of these kinds of questions, I think, can be answered pretty conclusively if you're honest about it by looking at other things besides these kind of dictionary or corpus linguistic things, the the other relevant texts in the Constitution, the historical background, and so on. And when you kind of isolate this and then say, this corpus linguistic analysis, and say, well, it's inconclusive, therefore it can be either of two things, that's, I think, a mistake, because you really need to put this kind of analysis in the context of what I would call a more traditional legal analysis of the text, the structure of the Constitution, all the relevant evidence. So I think it's just another illustration of the way in which this corpus linguistics analysis, standing alone, is kind of risky, because you forget about all the other kinds of things you need to do. And with the Second Amendment, there is a lot of other analysis that can be done that clears up a lot of these questions, in my opinion.
I have one question that kind of goes to how far can corpus linguistics take us by looking only at the words used in the creation of a right. Going somewhat similar to Judd's question about are you asking the right questions from the outset. And I wonder if for certain rights provisions, people may have talked more often about the power that they wanted limited rather than by the right that they wanted protected. And so when you have a limited set, is there more to be gained from looking at antonyms or opposites in this sense? So you have the material on page 9 in which you talk about synonyms to keep, but I'm wondering about whether you considered talking about antonyms to keep, opposites. So the idea of, was there discussion about taking arms or take arms, and could that inform our understanding of keep? I think in this particular situation with the word keep, when you have another provision of the Constitution which specifically authorizes the taking of other kinds of property, that keep may have been chosen for a specific purpose there, and learning more about what take arms might have meant could inform part of that discussion, particularly if it is in fact true that when you're talking about rights, the way we talk about rights today may not have been the way that they talked about rights then, and they may have talked more often about the powers that they feared be exercised than necessarily claiming that they had a right to the protection against that exercise of the power.
So maybe you've already done this, but if I were doing a study of the various words of the Second Amendment, the words that interest me the most are right of the people, and especially because the same phrase, right of the people, is used in the Fourth and First Amendments too. I know the most, I haven't done corpus linguistics on them or anything else, but in thinking and working about the First Amendment, it is interesting that the rights of petition and assembly are the rights of the people. No mention of the rights of the people with respect to free exercise of religion, speech, or press. Maybe that's because petition and assembly are things that large groups of people do, and that might have some bearing on whether the same phrase in the Second Amendment is collective or not. It's also striking that the rights of petition and assembly extended to non-citizens, which refutes, I had originally thought that perhaps the people referred to the citizenry, but that's just historically not supportable. But I also wondered in the context of the Second Amendment whether the phrase could have to do with restricting the right to the citizens. I think of Ireland, for example, where the right to keep and bear arms was denied to Catholics, and there's I think there's at least my intuition is that there's an equality dimension to all of this, certainly in the context of freedmen in the immediate aftermath of the Civil War. That was the context. So of the people strikes me as very interesting. But then in the Fourth Amendment, it seems to be largely an individualistic term, although I'm not quite sure. And then maybe the term is used in other contexts as well. And so I would just suggest to you, if you haven't done it, that this is a very interesting question.
The distinction, and I realize you get this from Heller, but the distinction between individual and collective strikes me as a test that's going to be difficult to get from the materials, the information you want. and maybe a really kind of a gross false binary about these things. And maybe what I'm saying is obvious, but the term collective it has something of a kind of authoritarian sense. We're just looking at online etymology, but yes, or at the very least, an potentially unfree sense, in the sense that a collective bargaining, for instance, doesn't require that every member of the union actually want to be a member of the union and in the collective. Because a lot of the things you speak of as collective are just free associations where individuals exercise their free decision to act in accordance with others without any requirement that they get a license or a command or a permission from the governmental authority. And so it seems as if for Stevens he's trying to say, no, you need to be part of this entity, the kind of a recognized entity like a militia, rather than just be, working with others in the way that almost all free speech is, collective in that sense, because you want someone else to listen to you. So that's my main objection. It seems to me that when you call things collective, when they say we have a right together to defend ourselves for the common good, and that's a collective, not an individual right. There are formulations for free speech that are precisely like that. The people have a right to assemble, discuss, and for the common good, and they're not members of some sort of formal governmental association.
The collective individual binary is false, right? I think I don't like it, which is why I think our paper may be more of checking up on Heller than checking up on the Second Amendment itself. Let's see. Don, I like your idea of the antonyms. That's actually a very good idea. There's lots of discussion about disarming the people with King George and General Gage in Boston, and that might be a very worthwhile endeavor to expand. And Mike, we do talk a little bit about the right of the people in the First and Fourth Amendments. It's a good observation that it uses right of the people for assembly and petition, but not speech, religion, and press. I don't know quite what to make of that, but it's a good textual observation.
And that is that there is a terminological problem with the paper, and that is that the term collective right was developed in the 60s, 70s, and 80s by critics of individual right to keep and bear arms in defense of a states' rights theory of the right to keep and bear arms. It was the right of states to have a militia. That was called the collective right. That was largely abandoned in the early 2000s in favor of an individual right to bear arms in the context of an organized militia. And that's the right that Justice Stevens is talking about in Heller. He doesn't try to defend a states' rights position, which is the collective rights position. He tries to defend an individual rights position in the context of an organized militia. So your categories, I totally missed this, but your categories don't apply to Heller. Only one of your categories does. The other category doesn't. Unless you're redefining the term collective right, in which case I think it's misleading or it's potentially confusing for anyone who is familiar with the previous course of debate.
We need to make more clear what we mean by the term collective, and we weren't trying to.
You should use that word, because this has a reference in the debate over the Second Amendment, and it means something else.
What word should we use to define them?
Well, what Stephen says there is no great word to describe the new position, but it's an individual right to bear arms in the context of an organized militia. That is the right. There's no great label for it. The collective right was a right of states to have militias. So you're just taking a word that had a clear association, and this isn't just me saying so. This is Stevens himself, who's saying nobody thinks that. I mean, they used to think that. They abandoned it very quickly. But he said nobody thinks that. I'm only talking about this individual right, and that's what Heller's about, and that's what your paper's about. So you really shouldn't use that phrase at all.
Okay, I just want to reinforce what Randy just said and flesh it out a little bit more. Originally, the anti-individual right theory was the states' right theory, but that turned out to lead to such manifest absurdities that they started substituting the term collective right, meaning an individual right to do what the government tells you or what the government authorizes you to do. So it was kind of a word trick to get around the fact that the states' right theory just led to absurdities that nobody could defend. And so I think that's one of the things that's introduced so much confusion into the debate. It's deliberately been introduced into the debate in order to make it possible for Justice Stevens to make the kind of arguments that he did in his Heller dissent. The other thing I wanted to say was in response to Michael McConnell's point, about the right of the people, as it's in the First and Fourth, in the First Amendment, it's large groups of people and so on. I think it is quite possible when you put that together with the militia preface, the introductory preface, I think there can be little doubt that rhetorically this is meant to call attention to the fact that what people were primarily worried about at the time was that the people were going to be disarmed by the federal government for political purposes, and so that kind of political activity of the people defending themselves against a potential federal tyranny was foremost in their minds. Rhetorically, that's certainly true. It does not rule out, though, the possibility, which I think turns out to be the correct interpretation of the amendment, is that the right that's actually protected is the right of the individuals who constitute the people to keep and bear arms for that purpose, as well as for other purposes that were not very much in anybody's mind at the time, because there was no real danger in anybody's mind that the federal government was going to start enacting gun control laws and saying, you can't have a 15-round magazine in your pistol or something. Nobody was thinking the federal government was going to do that. But that doesn't mean that that right isn't implied by the general individual right to keep and bear arms.
Larry, you have...
I wanted to emphasize the importance of work like this. This is pioneering work, and I think there are lots of ways in which this paper might be improved. But I think it's very important to see work like this done. Just one thing that I think we need to consider is that in linguistics, in lexicography, and in historical lexicography in particular, it's all corpus lexicography work. No one would think that if we're investigating historical linguistics, that sort of the proper approach to figuring out the semantics of the 18th century is to look at two dictionaries. Or that the proper way to do that is to set a scholar out reading sort of a non-systematic set of sources and then reporting their intuitions about word meaning. And I'm not saying that investigation of the constitutional record is an invalid method. I think it's a very important method. But if we want to investigate 18th century semantics, corpus lexicography is the best tool we have. And for the law to appropriate that tool, the kind of work that Tom Lee has done and Stephen Morrison done and James Phillips has done and that Josh Blackman is now doing is very important. This is early days. There are many techniques used sort of by the people who do corpus linguistics for a living full time that are just beginning to make their way into law. And so I would just urge those of you who have doubts about the method based on the sort of the very earliest work to appear in law to withhold judgment a little while longer before you reach conclusions about the approach that is absolutely the standard approach in historical linguistics for investigation of historical semantics.
I want to thank James and Josh and Nelson for their presentation, and I also do want to thank Mike and Stacy for all the work they put into this conference, and all of you for coming out again every year. This is such a good meeting we have, I think. So thanks to everyone. Okay.
Thank you, sir.